All right, we're back live, and we're with Heather Lynn, and she is here on behalf of VisBit, which was the Vermont School Board's Insurance Trust.
Correct.
And after yesterday's testimony, VisBit reached out and wanted to have Heather testify on S-103, specifically the section that we heard about yesterday, which was this adding language to Title 16. So, Heather, I'm just going to go quickly around the circle here. Representative Tom Stevens from Waterbury. This is a whole new group of people that you saw a year ago, for the most part. Some of us are returnees, but there's quite a number of us who are new to this committee. So, Representative Tom Stevens from Waterbury.
Representative Kathleen James from Manchester.
Joe Parsons, I represent Newbury, Topsom, and Groton.
Ashley Bartley, I represent Fairfax and Georgia.
Caleb Elder, Addison 4 District.
Hi, I'm Elizabeth Burrows, and I represent Heartland, West Windsor, and Windsor.
And I'm Larry Labor. I represent Essex, Orleans, District 1.
I'm Mary Howard, and I represent Rutland City, District 6.
I'm Robin Chestnut-Tangerman, representing Rutland Bennington District.
Great, so welcome. The microphone is yours.
Great, thank you, everybody, and I appreciate you letting me testify at such short notice and via Zoom. Just for context, so that I can provide some surrounding facts around what informs the testimony that I'm going to give you today. The work that I do and have done since roughly 2000 has focused on counseling and training and defending schools on matters related to peer harassment. Vermont was at the forefront and passed a peer harassment statute back in 1999. And between 1999 and 2005, we wrestled with what the full impact of that statute would be for schools in terms of creating a clear understanding of what that would impose by way of affirmative duties to respond to harassment or bullying or hazing that was known within the school system. That process came to a conclusion with the Supreme Court decision in 2005, the Harwood decision, which I defended, Harwood Union High School, and established clearly that schools could be held to account financially and legally if they were aware of behaviors occurring in their school between students. And this was a unique concept because to that point, liability typically only rested where the behaviors were of the employees of the school system itself. This expanded that liability and established a duty for schools where they know about behaviors between students over whom they have far less control, no right to fire, no right to reject an applicant and say, you can't come to our school, you don't have the right behaviors for our school. And instead, where the school had information that that behavior was happening and the behavior amounted to illegal harassment and the school did not respond, the school could be held responsible. In the wake of that decision, there were mandatory procedures developed by the Agency of Education, which then told schools, what do you do when you hear about that kind of behavior? How can you respond in a way that meets that legal duty? The current version of that was issued in 2015. It gets regular updates. And my work has centered on explaining to schools what those duties are, how to meet those duties on a daily basis. And really in the last 5, 6, 7 years, I've even gone further to help schools create internal processes and to build up systems that will reflect these duties and basically click into place, because your statutes are quite clear that schools must immediately reduce to writing any information they have about these kinds of behaviors and within 24 hours review that information to determine whether or not an investigation of whether or not the policy was violated shall be launched. The requirements are quite strict. Employees must report any information that relate to these matters immediately is the current term, and the school must make a decision whether to launch an investigation within 24 hours. An investigation must be completed in 5 days, with findings announced in a further 5 days. So I work with schools day in and day out, helping them understand those duties. I provide trainings. In the fall through Visbit, I provide 9 hours. That is all content that is not repeated of training to administrators via Zoom in 3 3-hour segments on those requirements. I'm repeating that series this spring. I do it every fall and every spring. For many schools, I visit with them on a monthly basis for at least an hour with their administrative team so they can bring issues to me, whether it be in terms of systems or understanding these definitions or understanding these duties, or how better to educate students about these rules so they can comply with them. I have heard in some of the previous testimony some implicit suggestion that the pushback to this bill from these institutions is understandable because they would, it seems to be implied, not want to extend these kinds of protections to students. I can say clearly from my experience of over 20 years that the schools and the administrators that I work with are deeply committed to understanding these rights and providing these protections to students. I do these trainings all the time, and I see people coming back to the trainings time and time and time again, telling me this is really helpful. I better and better and better understand how I can protect students in my schools. And that's time that they can't get back that could have been spent on other matters, but they care enough to return for these lengthy trainings. So that's the perspective that I'm bringing to my testimony today. And when I look at what is proposed, there are 2 things that jump out. The first is the language on pages 3 and 4 of the section of the bill, which relates to 570F. And just simply put, it is an amendment to current law, a law that is designed specifically to explain when and how can you sue a school system and hold them financially responsible for the behavior of its students. That's what 570F does. And currently, it states that a prevailing party, someone who succeeds in that endeavor, will have to demonstrate that the harassment, and I'm now focused on this harassment recovery statute. There's been testimony about bullying and sexual harassment, and I'll get to that in a second. But this part of the bill would change that standard so that a student would have to demonstrate they were, as is currently the requirement, subject to unwelcome conduct based on their protected category or a category of their family member. And the amendment would say, and that's it. The current law, however, continues and says, and not just show that, but then show one of 2 other things. One, for multiple instances, there needs to be demonstration of, and I'm paraphrasing, substantial adverse effect on the student's equal access to educational opportunities. Or, if that can't be shown, for a single instance of conduct viewed from an objective standard of a similarly situated person, reasonable person, that it substantially and adversely affected their equal access to educational opportunities. Both of these requirements would be removed. And while I haven't listened to all of the testimony, I've either seen summaries of that testimony or looked at some, and I've not yet heard articulated what is the reason for the change in the standard. I, for the most part, and my firm defend the vast majority of cases where schools' response to harassment are challenged either in front of the Human Rights Commission, the U.S. Department of Education's Office for Civil Rights, the U.S. Department of Justice, and in civil claims brought in federal and state court. I'm not aware of any case that failed because the family was not able to demonstrate those two additional prongs. I'm not aware of any criticism from those agencies that we shouldn't require proof of those prongs. And again, this part of the bill is focused simply on when can you sue a school system. It will have an impact on how schools operate by extension, but this is a remedy at the end of the line which says, and now you can hold a school responsible for the behavior. What this does do, however, and again, I don't understand what the need for it was, but what it will do is it will divorce the basis for the claim from the school's own ability to regulate those students' behaviors. What I mean by that is to say, current law, before any such change, states that the school has the ability to regulate these behaviors, which are often verbal, because those behaviors are impacting another peer's ability to access education, which is indeed the right that they're entitled to under the Public Accommodations Act. School is a place of public accommodation, and the point of being there is to get educated. Where you remove consideration of those impacts and yet say to the school, now you shall continue to regulate the behavior, whether or not that impact occurred. The outcome of that will be that schools will sanction, regulate, and punish, in certain cases, behaviors which are still protected under federal law and Vermont constitutional law under the First Amendment. So there is a very real danger of setting up that conflict. So, you know, this for us and for our members, VSBIT's members, which are school systems, causes deep concern. And it's going to, as a practical matter, result in school administrators, when they act in these areas, having to seek much more legal counsel to say, how real is the danger of a First Amendment challenge if I am doing what Vermont law is asking me to do? So I'll now turn my attention to the definitional proposed changes in section 26. 16 VSA 11 sets out the definitions of various terms that are used throughout the rest of the statute. And one of those terms is harassment. And it is the generalized harassment term that has proposed amendments in your bill. It is not the definition that is specific to sexual harassment. Yet I have heard testimony in favor of these amendments that focus on concepts of sexual harassment, that argue that there is a need to remove language severe and pervasive from Vermont law in order to adequately protect students, changes which have been proposed in other bills with respect to employees. The request and the ask here is to apply it to student matters. The definition of sexual harassment with respect to students that is current law under 16 VSA section 11 does not contain that language. Your current definition in the statute does not contain the words severe or pervasive. It simply reads 26B1, sexual harassment means conduct including unwelcome sexual advances, requests for sexual favors, other verbal, written, visual, or physical conduct of a sexual nature, and goes on to explain it can include what we call quid pro quo, submitting to the conduct being explicitly or implicitly a term or condition of the student's education, or submitting to or rejecting the conduct is used as a component of basis for decisions affecting the student. Where you will find the severe or pervasive language will be in the Agency of Education's policy for the prevention of harassment of students, specifically the definition of sexual harassment, which augments the statutory definition and includes the additional language. You'll allow me to find that. Sexual harassment may also exist in student-on-student conduct that creates a hostile environment. A hostile environment exists where the harassing conduct is, and here I think is the relevant important phrase, severe, persistent, or pervasive, but it continues so as to deny or limit the student's ability to participate in or benefit from the education program on the basis of sex. So what we have is a Vermont-specific, student-unique definition of sexual harassment that is currently contained in the AOE's model policy. AOE has the power to change that definition, but this current definition aligns largely with federal law. What is being proposed instead in your bill does not relate to sexual harassment. It relates to the generalized definition of harassment in 26A in your statute. And that is defined much lengthier. You have it in your bill, you can read it for yourself, but there is a request in your bill to remove the words "and substantially" and the words "educational performance." My concern with those changes are similar to what I voiced earlier, which is that removes that educational nexus and consideration and justification and basis for the school to act against these behaviors for students. And in doing so, will expose schools to First Amendment challenges. And these are not theoretical challenges. Our current law, unamended, has already been challenged in federal court by a lawsuit supported by lawyers from the Alliance for the Defense of Freedom. I don't know if that's a name that is familiar to you, but they are an international group. They worked closely and in connection with the work to overturn the Roe decision. They file suits all over the country challenging statutes which protect student rights. And to date, we've not had any successful challenge to Vermont statutes, which again have been at the forefront since 1999. My concern is that with this expansion and taking away the nexus with the educational impacts and performance, we are inviting challenges from folks who are already seeking and looking for opportunities to make challenges. And the concern additionally is, to what end? We have a very robust harassment response in place as a result of existing Vermont law. We have had added to that 3 years ago the Title IX regulations, which were announced in 2020. And let me just review what those require schools do with respect to the subcategory of sexual harassment. There are a variety of forms of sex-based harassment that are not the same as sexual harassment. This is just for sexual harassment. And again, sexual harassment, as I understand it, has informed some of the concern driving the request that this bill be adopted. The Title IX regulations currently in place right now mandate that where a school has actual knowledge of behaviors that may violate the rule, haven't been proven to violate the rule, simply at the lower threshold of may, they shall meet with the victim and offer the victim supportive measures, operating essentially from an act as if perspective. Those supportive measures are measures like safety plans, homework forgiveness, counseling, alternative routes of migration through the school, alternative seating plans, et cetera, et cetera. That should happen within days of that information coming to the school's attention. There is no need that a complaint be filed. There is no need that the victim come forward and ask for help. Simply being aware of the problem sets that duty in motion for schools. Additionally, any employee in a Vermont school that receives federal funds that has any information that sexual harassment may be occurring shall immediately report it or face discipline as a matter of federal law, current federal law. Now, with respect to their definition of sexual harassment, the Title IX definition of hostile environment does indeed include language with respect to severe and pervasive. However, the guidance that schools must follow from the U.S. Department of Education's Office for Civil Rights states that in considering whether or not a student has been effectively denied equal access, which is the purpose of that language, they shall evaluate whether a reasonable person in the complainant's position would be effectively denied equal access to the education as compared to a similarly situated person not suffering the harassment. So the impact analysis in that language requires merely less than 100%, 0.01. They go on to state, in so doing, a complainant need not show total denial of access, need not show they already suffered any loss of access, need not show indeed any concrete injury for it to be considered sexual harassment, which triggers all the duties that I just identified. We also know the Biden administration is about to announce next month, within days perhaps, further changes and amendments to this standard. The standard will, if they follow through on what they published as their proposed rules last summer, change the standard so that hostile environment will exist where the conduct is sufficiently severe or pervasive that, quote, based on the totality of circumstances and evaluated, subjectively and objectively, it denies or limits a person's ability to participate in or benefit from the program. They will also seek to remove, if they go forward with these proposed rules, they will remove limitations on extending these rules to behaviors which occur outside of school. Electronic communications are currently covered in certain circumstances and will be covered in yet more circumstances with the changes. The Title IX regulations will change the definition of sexual harassment prohibited under Title IX. Those changes will come within days or weeks. It is appropriate for us to receive those changes, consider their impacts, and for AOE to then, looking at those changes, consider how to amend and augment any of the Vermont concepts, something they've already done, as I point out. Their definition of sexual harassment is already greater than your statute. Your statute does not define hostile environment for student harassment. It is only found in the AOE model policy. But indeed, that language, severe and pervasive, is unique. It is distinct from the Title VII language, which has caused the kinds of limitations that you've heard testimony on, limitations that have all been applied in the employment concept and don't have available as a defense to applying them the language that AOE chose. AOE's language is unique. So I submit to you that we have robust protections in place. We have systems that are being built up and continue to be refined within Vermont schools. I think it would be valuable for the committee to hear from administrators who apply these rules and do this work. I have done a lot of work with a lot of administrators around the state. I have trained whole schools, staff, and teachers on these definitions so they understand their duty to immediately report or face discipline as a matter of federal law. Your AOE model procedures implementing Vermont standards are very clear when you look at the model procedures, which read model procedures on the prevention of harassment, hazing, and bullying of students, have on the front page at the very top, any employee who witnesses conduct they reasonably believe might constitute harassment, hazing, or bullying shall immediately report it. So we have very aggressive procedures and requirements and duties. And again, what I see around the state, if anything, is a commitment to doing this work, albeit there is more work to do in terms of understanding how to do this effectively, promptly, and fully by administrators who, as a class of employees, have experienced incredible turnover, a lot of early retirements, a lot of new faces are in these seats. I see new faces at my trainings who are learning this information for the first time. And it is a dense amount of work. A lot of time has to be put into it. And I always tell them it's an onion. You're going to learn more and more the more that you do this work. If I were empowered to make a change tomorrow that I think would expand protections for students in these issues, it would be to fully fund in every building an employee whose sole job it is to do these investigations, to process this information and launch these investigations. Instead, those tasks are spread amongst administrators who also have many other things on their portfolio and their plate. Additionally, I would, with the wave of a magic wand I don't have, create a full curriculum to help educate students on these rules. The existing rules you have would, if fully understood and complied with, truly make a difference in Vermont schools for the experience of students. We have been asking at the state level for many, many, many years for state-specific information and examples on how to train students about these. The national resources that are available are inappropriate for reasons related to, not the least of which, your unique bullying statute, which is, in my view, the most aggressive of its kind throughout the country. There are no requirements that students who suffer bullying in school demonstrate any in-school impacts in those cases under your current standards. So to use a bullying training kit from a national group would be inappropriate. They also speak in terms of things like, you need to prove a power imbalance. Vermont doesn't require a power imbalance in order to demonstrate that bullying has occurred. So I know I've gone past 11 and I'm mindful of your time, but those are the main points that I wanted to communicate. And I will take your questions if you're inclined.
Sure. And thank you for making time in your schedule. We have at least just one question, and I do want to be mindful of the other witnesses that are here, some of whom tried to testify yesterday. So Representative Burrows, you had a question?
I actually have a few questions. Can I email them to you and then share your response with the rest of our committee?
Of course, I'm happy to help.
But I guess the most glaring question is, you talked a lot about sexual harassment. How do you think our state provides protections for students against racism and gender-based harassment?
Those are subsumed within the general harassment definition. And thank you for your question, because I did not spend a lot of time, because my perception was there was a lot of focus and testimony on sexual harassment. But 26A, which is in your bill, defines harassment generally. And that protects students on the basis of other kinds of sex-based harassment, gender identity, race, religion, all of the categories which have been recognized and protected under Vermont public accommodation law are reflected and incorporated in the prohibition on harassing behavior. And how do those work and how effective are they in school? There is, I would say, a pretty good understanding of the framework of that definition, and the application of that definition, I think, has gotten to a good place within Vermont schools. However, I would say that the behaviors which transgress and violate those rules have, in my experience, having done this work for 20 years, exploded in the last 3 years. Now, when we see data, we often ask what's causing that. I don't, from where I sit, perceive that as an indictment of the current definition, but I see it as part of a larger socio problem we see across all settings, which is behaviors that many people would not have engaged in 4 or 5 years ago are now being greenlit from a variety of prominent places in our society. And students are following suit and challenging and engaging in behaviors that we are increasingly determining are race-based harassment, and they are getting sanctioned under these policies. These policies provide for an opportunity for anyone who is found to violate harassment to appeal that decision to the school board. I have had more appeals to clients of mine, school boards, where parents complain, my child has been found to engage in race harassment. How could that be? I don't understand. They are aggressively pushing back and challenging the definition that currently exists. By and large, those challenges are not successful. I would have concern if we change the definition in the way that's proposed here, those challenges would become ironically more successful, not less, because it is the board which sits and decides those cases. And I could see them, often they already struggle with these cases, being receptive to First Amendment concerns if raised at that level. So we have a comprehensive statute which addresses all manner of race, creed, color, national origin, marital status, sex, sexual orientation, gender identity, or disability based harassment. And
Okay, Heather, I'm sorry, I have to stop you here because we're about to lose another witness and I want to make sure that they have an opportunity to testify. So,
of course, I completely
but
understand.
Again, thank you for being available this morning. Appreciate your testimony. You're free. There's folks here from the School Board Association, the Principals Association. So, but we appreciate your time. Sharing your thoughts on this. Yeah. Take care.
Be well. Take care. Bye-bye.
Is Kara still here?
Yes, I'm still here.
The microphone is yours. I'm sorry that we're running a little bit behind schedule, but I'm happy to get you in to testify.
No, that's absolutely fine. And please excuse me, I'm testifying from my car because it's a work day, but my name is Kara Lee Kennedy, and I've worked for years with the NAACP on issues of harassment in regard to my son, and was offered this opportunity to speak based on my experience, because I think this is very important. So I won't take up too much of your time. Just kind of want to give you a brief overview of my experience in regards to racism in the school systems in Vermont. So I think that it's important that we stop putting the burden on children to prove that they are being harassed in order to be protected. Our experience in 2 of 3 Vermont schools in the last few years has been awful in this regard. I've had to transfer my Black child out of 2 schools because it just wasn't safe for him. So I'm just going to kind of go through bullet points of my experience, and then I guess you can just kind of make your judgment based on that. At a Vermont school in 2018, a teacher struck my 6-year-old for no other reason that I could find other than he was a single Black child in a room full of laughing children. And there should have been an investigation. I reported it to the police when the school really didn't do anything at all except tell me that I was wrong. And they decided to not investigate. So I had to change schools because it was just a school issue. I guess I don't really understand all of the laws. I am just a parent, but They didn't even show up to the school to investigate. When I told the school that we needed clearance to transfer schools for safety, I was threatened with literal knocks at my door at a new apartment in a new area so that we would be within the geographical vicinity to be at this new school, just to prove my residence, because there was going to be some lack of diversity in the school that we were leaving. And I always think in that case, like, what about the families who didn't have the financial resources? At that time, I was paying 2 mortgages, and I actually had to rent another apartment in a different area in order to change schools because it wasn't safe for him there. After transferring schools and renting that apartment, I reported multiple instances of racial violence against my child at the new school, and we were met only with disciplinary actions against my son. When disciplining him was something I was no longer willing to do, I called the school and requested a legal safety plan, and I was told that we could get a 529 plan. Knowing that this would stain his academic record, it was the only way that they told me I could protect him by separating him from the classroom rather than protecting him or separating the aggressors. Additionally, he has 0 disability or basis for 529 plans, but I was told by the school that I could get a diagnosis. Mind you, this was a principal, not a doctor, telling me this. And while my son has spent years in counseling with licensed therapists because of the issues he's dealt with in Vermont, he's never been given any diagnosis, and there was never any recommendation of diagnosis from a doctor. So it just didn't really make sense that we couldn't create a safety plan, but that my son's.
Anyone know what a 529 plan is?
So children who meet that 22-point discrepancy on an IEP get an IEP. Children who do not meet that 22-point discrepancy get a 529 plan. That helps develop items or criteria, whatever you want to call it, to help them be successful in the classroom.
So it's a similarly individualized plan, but without necessarily having met the other metrics necessary to trigger an IEP.
Correct.
Thank you. I tried to look it up, but all I was finding was a college savings plan. So
I'm not sure if we're going to hear back from Carolee.
I'm asking her.
West Hall, it should be.
Be in West Pollitt.
That you, Carolee? There you are.
Hi, I'm sorry. It kicked me out and then asked me for a password. So sorry.
That's okay. It happens. It happens, especially if you're in West Wallet.
Yes. So I'll just continue. So yeah, the 529 plan, that was a pretty big, it almost just, I don't even know. I couldn't even find words to describe like how frustrating that was, because it just didn't really make sense. At that point, I involved the NAACP to create a legal safety plan with the school, and I actually brought them into the school. And I actually had to tell the schools, I will no longer communicate without this representation CC'd on all correspondence, because I didn't feel safe based on the recommendation I was given to the 529 plan. We did go in, we created the plan, and it was completely disregarded in the following school year. Now, the plan, it took me all year to get them to agree to, and we all signed it at the end of the year. And I called countless times in the middle and end of the summer to say, we need to make sure that this is in place. And when he began school the following year, I was told, they'd get back to me. And on day 3, he was beaten up very aggressively by one of the children that was a regular aggressor for years, who was actually supposed to be physically separated from my child based on the original safety plan. He was beaten for 5 minutes, and it was children that stopped him. It wasn't teachers. That was, and then when I called, they said that the safety plan will be in place the following week because, that things had, it's just busy with the beginning of the school year. And when I got it back, the verbiage had been changed. Everything about it had been changed. I at one point brought in outside equity trainers to be a non-bias option to go into the school and help with some staff training. And after they agreed, that trainer was ghosted by the school and was never asked to return. Like I said, he was beaten after the safety plan was disposed of, or at least not put into effect until 3 days later, without consent. And my son ended up fleeing the school at the end of the day, and he was suicidal. And so at that point, after multiple reports of this racial abuse, I called the police again, who again decided not to investigate, regardless of the fact that the threats including being stabbed on school grounds. We again hastily relocated to West Paulet in August because of this issue, and had to again buy another home on the brink of what, maybe I'm a financial advisor and we are looking at some pretty intense things going on in our economy, and certainly buying another property this hastily was a choice that I felt like I didn't really have a choice to make. It was the only option to keep them safe. We're now trying a third school here in Vermont, and it's within the same supervisory union. And although in this circumstance, we are having a much better experience, and it seems like the investigative techniques that are written down as rules for the school are being followed this time. And I do appreciate that very much, but the fact that at 2 other schools within the same supervisory union, this form of harassment and racism and abuse has gone on for years. I mean, my son is 11 now, and this started when he was 6. So it's been really, really tough, and it shouldn't be up to the children to fight with adults to have somebody validate the fact that they are being abused, especially on the basis of things like racism or all of those other protected classes that we spoke about today. My child should have safety in schools, but he hasn't. And there's been no reporting mechanism to ensure that he does. The law will prevent this kind of trauma from happening to other children because it'll allow for an immediate investigation that can't be pushed aside from the school, where police can't just make a choice not to investigate and leave it in the hands of the school, which I think is incredibly pertinent, because in my experience in talking to other parents of Black children or biracial children, they're also experiencing these things. They just didn't know where to go. They didn't have the resources or even the financial resources to say, I can't do this anymore. Let's go buy a new house. Let's go get a new apartment. And for those children, they don't have help. And I feel like it in turn turns into these children are acting out in response to these things. And then they are looked at like they are the aggressor. They are looked at like they are doing something wrong, but it's not up to our children to encompass that kind of emotional intelligence to say, this isn't right, but I can't react. And it is up to us as adults and as educators and as lawmakers to make sure that we are really protecting these children so that they feel safe enough to not react so intensely. So yeah, that's what I've got to say. Thank you for listening.
Thank you for being able to call in. Any questions for Carolee? Representative Elder?
I don't have a question at this time, but I just wanted to say thank you for your testimony. And I'm sad to say that that your experiences are paralleled by things I hear from constituents in my own district with Black children in our school systems. And it is a totally untenable and unacceptable situation. And I'm truly sorry for what your son has gone through. And I hope that we can come up with a policy change that will provide the protection to public education for all children in Vermont that they clearly deserve. So thank you for taking the time both yesterday and today to give us this testimony.
Of course. And I think it's important to note that if this were an experience in one school, then maybe we could say this is a school issue. But I have traveled Vermont. I have relocated now twice. And we are on our third school where this is the same, we've had the same experience at multiple schools, which tells me, and I think it would tell anybody else that's paying attention, that this is a law issue rather than a school issue. This is a systematic issue. This is not just a single school that dropped the ball. This is across Vermont. And like you said, it is parallel to a lot of experiences, and a lot of experiences I've heard as well. So thank you for hearing me.
Thank you.
Representative Chestnut Tangerman.
So you said that your son is in a better situation now. Is that accurate?
So correct. So this is our third school. It's much smaller, and I have to say that part of the ability for us to look like, as a parent, made to feel like I'm being dramatic, is because we do get so headstrong and we do get so defensive. And I did go into this third school with my guard up and immediately sat down with the administrators and said, this is our experience. This can't be our experience. I immediately put him into counseling in the school. I immediately talked about an outline for a safety plan. And I immediately talked about some equity training outside of the scope of what is required by the schools. And this school has actually asked me to provide resources, which is farther than I ever got. And in this new school, when he experiences racial issues, which he will continue to experience because of where we live and the lack of diversity, he was actually given space to talk in front of the class and educate in front of the class and be heard and be validated, which is such a different experience than he's ever experienced before. So far, we are very happy. But like I said, this isn't, we changed schools once and the experience was different. This is, we've been to 3 different schools. The issue of racism has been prevalent in all 3, but the reaction has been appropriate at only one of them. And I think that that's really, really important, that, like I said, we realize that this is an issue above individual schools.
Can I get your contact information from Ron and follow up with you?
Yes, please do.
Thank you.
Does anybody else have any questions for me? Because if not, I've got to run back into work.
Go ahead.
No, I was just gonna say thank you for saying this. I just wanted to echo that. I think it's unfortunate that is your responsibility to provide resources to the school to educate them on how to properly handle situations. And so, as was already stated, parallel, received, and experienced. So thank you for your testimony today.
Thank you so much.
I was wondering, so since and kind of echoing what Representative Lamont just said, since all of these are all within the same supervisory union, how has the supervisory union overall and the superintendent and the school board responded to any of this?
In 2018, when I requested that my son be transferred outside of our town's school. So it was, we lived in Danby at the time, and I wanted to transfer to Manchester because there's more diversity. I actually got a personal phone call from the superintendent, and it was a very loud and intense phone call where I was told that I would be taking away some of the diversity in a very non-diverse small town school, and that would affect the school negatively. And my challenge to that was, it's not only not good for my one Black child to be the only child in the classroom of color, but it's not good for all of the white children to only look at one person as the demonstration of an entire race. And regardless of kind of my pleas at that point, I was told that because I would be changing their diversity ratios, that somebody will knock on my door at my new address to make sure that I live there.
I'm
So
sorry.
I quite literally had to go rent an apartment. I was at that point in time, and I know this is kind of personal, but just to think about the experiences of a family as I was going through a divorce. I was managing 2 mortgages on my own. I was a diner waitress at the time. I was working, endless hours, and I literally had to move to Manchester and rent a 3rd location just to keep my son safe. and the police didn't show up.
Thank you.
No, thank you for sharing your story, Carly. It's a hard one to hear. So I'm sorry that you and your family are glad you and your family are persevering, and that's what parents do for their kids. I hope you can find the support in your current system to help make it a better world.
Absolutely. And I don't know if this is relevant at all, but just in terms of shining light on the point that this is a systematic issue within our state, and that it is up to legislators and lawmakers to really make this difference outside of school. We've experienced, of course, countless things just because of where we live, but in that town of Danby, somebody vandalized our home in the middle of the night and wrote 802 with the N-word and said, "You can't stop us," in red spray paint across my entire house. And when I called the police and asked them to patrol, they gave me a short lesson on Vermont's gun laws and said that they are going to come out and patrol Danby for that. So it is very much a law issue and a systematic issue, and not just a school issue. And it's very important that we all pay attention.
Thank you. All right. Appreciate your time.
Thank you so much. Bye-bye.
Thank you. All right. Next up on our agenda, we have Jaya Holloman.
So I'm present. Is
Yes.
there a best place for me to be?
Oh, in the chair. I'm sorry.
Myself on the TV.
No, please. We enjoy the intermittent.
Do you have to look at this while I'm here?
No, you're going to face us and
Feel free to ignore
just
this.
make believe it's normal.
Oh, right. This is totally normal. Which ironically, the experience that was summarized to you by our previous speaker and mother is normal. Right? Like, this is not normal. That I took the day off to come and speak to you. This is also our lived experience. Right? I wasn't meant to see that. So good morning. I'm really nervous, and I will say transparently, I get nervous, though I'm very confident, and though I'm very outspoken. I get nervous when I have a lot of big feelings. You talk to kids about big feelings. I have a lot of big feelings. You cannot have the experience of being a mother, whether you are white or black. At the end of the day, a mother to a black child, and not have big feelings. Wouldn't be human. So my nervousness is going to be in the way of how you perceive me, probably. I might feel angry. I might seem angry. I might seem impassioned. My voice might shake. It doesn't mean I'm not speaking truth. It doesn't mean that there's not an opportunity here today. I'm scared to be here. I didn't want to come. I'm really tired. If I am this tired from 14 years of learning, watching racism destruct individuals and destruct confidence and destruct happiness and destruct joy and destruct families and relationships and opportunities and education, if I am this tired, I have no idea what it is to be a family in a, let's say, racially marginalized identity, where this has been passed and passed and passed and passed. I have privileges. I'm sorry I have to say that, and I am exhausted. I didn't want to come today. I wanted to rest. I wanted to heal. I want someone else to do the labor, because this is a lot of labor. And yet, what I knew was that there is an opening here, not just for me today, but there is an opening in your legislative body, in your committee, for the potential for something. Maybe it's small. We don't know the measurability of it yet. For something to change that might have an impact. And it will not be the case that as a mother, you do not advocate just only for your child, but also all the children and families that don't have the ability to come and speak to you today for many reasons. The stories are painful to tell. It's re-traumatizing, we know that, right? The stories are painful to tell, and our children are learning that to get through, put your head down, don't talk about it, try to do your work. So since there are many, many, many more voices that can't be here, I'm here. That's a long preamble. It's why we're here. While I want to respond to Heather Lynn, while I want to respond to this total rift between what the language reads, which is clear. Language is not unclear. There is a total gap between the language, my hands are a lot, I need to have them up it, and the action on the ground, which we just heard some of. Right? It sounds nice when you hear, it sounds clear when you hear some of the testimony. It's not clear in action. So I come to you today as the mother of a Black teen who has endured, like many, repeated, ongoing, persistent racial harassment while trying to access his education in a place of public accommodation and while trying to find belonging in a school community. I'm in a unique position because there is a story to tell, and you all need to hear the stories, right? Some of us know the stories and some of us are new to the stories. You don't know what you don't know. But I'm in a unique position in that I can't tell the story because in deference and in respect to a ongoing Human Rights Commission case in process. Given that, I'm here to tell you what I can tell you, which is about my son, and what I can tell you from what I've seen. So thank you for bearing with me. My son, I will cry. It's part of it. You are not a mother if you haven't shed a few tears. My son is Rwandese. My son is also American. His name, when translated, means peace and love. He has embodied that since day one. He has been I will read it because I will cry, brilliant, capable, curious, kind, indulgently joyful, dedicated, focused, witty, and deeply feeling child. Until he was racially harassed. And then he was racially harassed. And after it was reported, he was racially harassed. And then do you know what happened? He was racially harassed, and then harassed, and then harassed. And I'm not making that up. In the place of school, with reporting systems, with the language as it stands, that arguably is very clear for administrators to follow and implement. Just yesterday, in the car on the way home from the new school, where we relocated after relocating, with the privileges to do so financially and job-wise and all of that. Yesterday in the car on the way home, when he was sullen, he said that the last time he felt okay, not good, okay, was nearly 3 years ago, before the difficult year I'm referring to. 3 years before the difficult year. What I have witnessed in him since, I can't testify to. I can't say how he is. I can tell you that as a mother, there's been a marked change. The qualities that I read before are in there somewhere. They are so covered up. He is struggling. You might say, he's a teen. Teens go through stuff. Yeah, it's totally true. He is a teen. And I can assure you that what we are looking at is the lived traumas. This is not a challenge. This is not a hard time. This is trauma when racial harassment, all the other protected identity harassment, fill in the blank, occur. Hopefully he'll learn new ways, he'll heal, he'll compensate, but there's a good data on the legacy of trauma, and let's name that this trauma was endured during a formative time during child's development. Trauma doesn't go away and it impacts every relationship, including those within the family. To say that our time has been stressful, scary, angering, isolating, costly, exhausting, and destructive would be inadequate. When we set out in a new school, we didn't look for a community devoid of racism. We know that doesn't exist. That's not what we were expecting, just like she's saying. What we were looking for, what we hoped for, was a community where the adults in charge responded swiftly, thoroughly, and with care to incidents of harassment. That the adults would not look the other way, that the adults would not choose the path of comfort, that the adults would not sweep it under the rug. Like many, many abuses, they shall not be named. We all know some of them. There are compounded traumas. The initial trauma, subsequent failure to act by people in power, the impossibility of proving something, the dismissal, and a total failure to protect. Each one is an inception point. I'm not a legal scholar. I can't speak to my experience. I can only speak to my experience and my observations. The standard of severe and pervasive, I'll focus on those words. I know you have other changes at the helm. The standard of severe and pervasive is not victim-centered. The standard centers people in power. The decision makers, think about a school. The decision makers are almost without exception likely to not have experienced any marginalized identity. Another way of saying this would be the people in power are largely white, cis, het individuals, right? We know this. We are expecting people in power to be the ones deciding if the standard of severe or pervasive has been met. When presented with, let's say, a child of color reporting racial harassment, you can say the language doesn't say it needs to meet severe and pervasive. The language for the HHB says if any event that may have been motivated by race, gender, were to happen, it needs an investigation. The schools, I can tell you on the ground, are not investigating it. There are no teeth. They're scared of no things. It's exhausting. They have thousands of fires to put out a day. They don't have one person that just does this. There's a lot of reasons not to do the work. There are no teeth and no levers for accountability, for implementation, as the language stands. What they know is no one can prove severe or pervasive. We've had testimony on that. For the child being harassed, how much harassment under this model is acceptable? How often is it acceptable? Is it okay if we involve the use of epithets? Is it okay if the victim laughs maybe just because of nervousness or defensively? Is it okay if the people were friends? Is it not okay only if a white hood or a threat of physical violence is present? Where are the lines? These decision makers are dealing with an onslaught of issues. What they see is a complaint. Maybe it doesn't seem that bad to the adults. Jimmy seems fine in class. That's not my kid's name. Not severe, not pervasive. They seem fine on the playground. They don't see what many families often see. Our kids crying themselves to sleep. Shame, loneliness, pain. Our children experience things differently than adults. And they need to be centered and believed and protected. As the harassment my son was experiencing became repeated, and as the school's response repeatedly did not meet the obligation and the duty as set forth by the adopted policy, it became evident that I would need to heavily advocate. I spent countless hours, which I would do again, working any type of connection that I might have, ed justice organizations, legal resources to help me try to understand what the policy meant and what would happen if they weren't following the policy. Who do you go to? Where are the levers? Where's the accountability piece? Who do you ask to come in? Conversations with the school, like this previous person said, was successful on the third time. Stopped when the work became too much. Stopped. There was no inroads to work together with stakeholders and the school. So where are the levers in the broader community? I worked with former administrators. I worked with legislators just to see, am I going crazy? How does this stop? It cannot be that a child goes to school every single day and tries to be in the English class and tries to be in the science class, but is dealing with gross, meaning lots of it, blatant racial harassment. It can't be. The answer is there are no levers. If one of you has a lever that exists, please contact me. Because I get calls from parents all the time looking for levers. There are no levers. I have more to say. I want to acknowledge the privilege that I had with my time, capacity, networking, ability, and resources. It is not common. It cannot be that students and families proceed through alarming rates of harassment in schools without more incentive and duty for the schools to respond. The burden of responsibility has to be with the adults in the room, with the systems like yours, with the schools, with the administrators who hold the power to do something. I mentioned before my sadness and my anger. This is ridiculous. I mean, it's ridiculous. That we're even talking about this is like, really? At the reality before us, my son's story is one of many. I have heard story after story after story, not from constituents, but from parents who are desperate to know how to help their kids and how to work with administrators, and even how to be supportive to administrators who are struggling to know how to implement the things, right? Lots of people are reaching across and saying, how can we work together? Here's some groups that might help. It cannot be that this burden lays with the parents. There are kids not reporting that they're called the N-words so many times during one day, constantly during one day, because they wouldn't be able to go to class if they reported it each time. In fact, they have reported it, and guess what happened? No thanks. They reported it again, and guess what happened? No thanks. Guess what happens? They stop reporting it. Then we say, it's not an issue. We don't really have any HHBs in our school. Okay, sorry about that. These kids just take it and take it. It doesn't feel good. The adults have showed they can't be counted on, and it hurts less to take it than it does to say something and have nothing done at all. The system as is has no levers. Harassment in the schools is rampant. Heather Lynn has testified to the exponential, almost uncontainable growth of harassment. We know it, we have the data. The legislative body has the opportunity to change the language that currently allows for continuation of a culture of harm, a culture of trauma that to both thrive and persist right now. You are the adults in the room with the power to decide to make this a less severe and less persistent, pervasive reality for so many of our students with protected identities. If you can change this for employees and for housing sector, you can change it to add a layer of protection for the most vulnerable among us, our children. If you decide not to strike the language, not to make the amendments from the harassment language, I would sincerely ask you personally and as a committee to consider and grapple with honestly who the decision is protecting. I wish I could respond to everything. I don't know the person who came before me. She's my neighbor, so I will now meet her. Thank you.
Thank you for sharing your story. I'll acknowledge that, yes, it triggers a trauma response, and I appreciate you overcoming it for the time being. Overcoming your nervousness. You weren't nervous, you were yourself. And I thank you for sharing your story, your son's story. It's hard to hear. And we'll be working on this bill over the next day or so for sure. See if we're have a conversation about it. But this was an important piece to hear.
Thank you. I would like to just add one thing, which is your time constraint. I cannot tell the stories of these children. I implore at some point the committee to make a space to collect what these children are experiencing, what they're feeling, and how it impacts them. No mother can speak to that.
Thank you. Questions, and we do have one more witness. Big space for that as well, but Representative Elder.
Yeah, again, a brief comment. Thank you very much for your testimony and for sharing your awful lived experience in our public school system and that of your son. I don't mean to mischaracterize it, but it sounds like it's been awful. I want to just mention, since we have some education folks in the room, and I used to be in the education committee, and this is not that, but we've undertaken the past year a revision to a way that we resource students in our schools that has to do with pupil weighting. And I've always been uncomfortable with the fact that in Vermont, our sort of proxy in some ways for students of color is this English language learner weight. And the truth is that if you look at most students of color in Vermont, they are in districts like Burlington and Winooski, where many of them happen to be English language learners. But for students who are part of a protected class, who are neither an English language learner nor living below the poverty level, they receive no extra resources in our system whatsoever. And clearly, the schools need extra resources to protect these children. The fact that a superintendent would go to our last witness and say you somehow owe us the diversity of your student in our school, that we have no means to protect them, is worse than an outrage. And despite the fact that that makes me angry hearing the story, I'm also cognizant of just how much more work there is for schools to do than they are resourced for. And so I just want to say that our school weighting needs to figure out a way to incorporate protected classes, students, so that there are non-white students in our schools who are facing the pervasive threats that you're describing, I think very accurately, that schools have a clear obligation to protect those students, but also have a clear source of capacity and resourcing to protect those students in accordance with how great a priority that is. And the truth is that our current public education system makes no additional investment in these students, and it's wholly inappropriate. Thank you for testifying today. I just wanted to say that.
Thank you, John. Thank you.
Thank you so much.
And If you have your remarks on electronic form that you want to share with us to post, please feel free to email them to Ron. It's up to you.
Okay. Thank you so much.
Thank you. Judy Dow. First of all, Judy, it is so good to see you in 3D. I think it's been quite a long time.
My feet are legs are too short, I can't reach anymore.
There's a cow on the right hand
I
side.
saw that.
You might be all the way down here.
Okay, I'm down
I
there.
lowered mine just thinking about it.
Thank you.
So Judy, welcome to this new formulation of our committee. You are the executive director of, tell me if I'm gonna butcher it, the Jadakina?
Did that, can that?
Okay, close, but not there. And you wanted to share your thoughts on S103.
I do. My daughter and I have an example of a severe and pervasive case, and we went to court and we won. And I wanted to present that to you because I've been hearing there are no examples. And I'm feeling like, what are we, something in the trash? We went to court, we won. But before I do that, I want to address some of the words from the lady, I don't know where she was from. She was talking about all the laws and the training that she does. And she mentioned the policy of the Agency of Education. Myself and Mia Schultz filed a complaint around mascots. And we got a call a month ago from the person in your position in the Senate. Remember his name? I want to call him the dude, but I don't.
Can't be in it.
I can't be it. Thank you. And he asked if we would come and talk to them about the law. And he asked us additionally if we would meet with Agency of Education, which we agreed to both. We went to meet with the specific person he asked us to meet with, and she was not there, but a whole litany of lawyers were there. And what people that call themselves the boss. And they told us quite clearly that they did not feel they were competent enough to receive an appeal on the mascot. They were not culturally competent and had no cultural humility. They could not make the decision. So I'm telling you this story so you're careful as to what you pass on to these people, because they are in turmoil. They are not competent enough to handle cultural differences, cultural issues. They don't have, in their words, the competency training that they need. So I just wanted to start with that because she was really big on the Agency of Education and their policy, and whether they have a legit policy or not, they don't have anybody there that understands it, according to them. So, bless you. So I have been re-traumatized by listening to the previous stories. I have my thoughts written down. I'm going to try to tell them the best I can. I went through boxes of paperwork last night to find the documentation I needed. My daughter enrolled in a class at the University of Vermont. She was majoring in anthropology. And the professor said to her that Abenaki people are so intermarried that they're unable to receive federal recognition, or even they don't know their history. He stated that all Abenaki were drunks and alcoholics, and the archaeologists were doing the best they could to teach them their history. And so after class, my daughter went to talk to him about the possibility of him coming to one of my classes so that he could indeed understand what Abenaki history was. I've been teaching for 38 years. The last 15 years, I've been working to do teacher training around the state. I've taught in 205 schools, probably many of your schools. And so she went to talk to him. There were a few kids left in the classroom. And he compared to her, the Benicky is the same as Osama bin Laden, that we both hated Americans. And his final words to her was, "Fuck me, fuck you," and he walked off. So my daughter didn't know what to do. She wanted to drop the class, and we had this discussion about, these are your peers. They're gonna go out with these myths about the Benicky people. Do you want that to happen? And she was in her senior year, first semester of her senior year, and she's like, no, I'll stick it out. And so she did, and she filed with the Affirmative Action Office a complaint. Once he received word of the complaint, our days were filled with unbelievable words from him. He didn't know how to use the computer, so he wrote everything out in his own handwriting. The classroom became an unsafe environment. He would bring wine to class. He would throw chalk at students who fell asleep in class to wake them up. And he would write to his peers, to the dean, to others, saying that she was an out-of-control woman who needed to be healed in. And so as time went on, the harassment continued in the classroom. And so we wrote to the Vice President David Nestor and asked if what to do about his harassing. And while we were in the process of doing that, he filed harassment on my daughter. And my daughter was never told about it. My daughter didn't know that this was a college process that he could go through. And when she found out, he wrote a note to her and said, "What's going on? You're toast," in his own writing. My daughter filed a retaliation claim, and the conclusion was that he was found guilty of retaliating. He stalked my daughter to work. She had evening classes. He stalked her to her evening classes. When he couldn't make it, he would call the office to see if she was in class that night. He wrote a letter to Joan Smith, the dean, and there's some quotes that he wrote in here that I want to share with you. "Hasn't this idiot ever heard of drop ad? She's arguably certifiably paranoid and on her high horse again. She needs to be healed in." Smith, the dean, wrote back that she is not asked to speak to him personally because he personally released details of my daughter's file to the public, including her SATs scores and the fact that her first semester as a freshman, she got caught for drinking on campus. He sent that to her professors. He sent that to the dean of the chair of the department. Then Joan Smith continues, "Nevertheless, that access was a privilege allowed you the use of the file, for legitimate education purposes. Instead, you use this information not to advance Ms. Dow's education, but to defend yourself and to discredit her. You have no right to this confidential information. The only issue I am addressing is how you responded." That response was intemperate. It was disrespectful of a young student to whom you had responsibility, no matter what you thought of her actions. It was a misuse of confidential material. And finally, it was irresponsible to an institution. So in the spring, he was going back to his fall classes, and in the Vermont Cynic, the UVM newspaper, he said he was going to come back and teach one downmanship, victim versus loser. So we tried to get a lawyer. We went to 26 firms in Burlington, and UVM had made connections with all of them. So they considered UVM one of their clients, so they could take us. And they were sympathetic, but that was it. No, they couldn't have us. We went back to the affirmative action office and they told us that he hadn't done anything yet, so there was nothing they could do to stop it. So like the other mothers, don't poke the mama bear. I signed up for the class. So I attended the first class and got the syllabus, and on the syllabus, it said he was going to retell my daughter's story. And of course, I knew it would be subjective. It would be from his perspective. I said nothing in the entire class, not one word. And when he started taking attendance, and because I was clearly the oldest person in the class, when I said that I was here, he like screamed and told everybody to stay in their seats. He would be right back in 20 minutes. So we went and got the Dean of Arts and Sciences and security, and they came back to remove me from the class. I was like I pulled out my student ID and I was feeling like, go ahead, make my day. And of course they couldn't do anything. So I went back to class and he dismissed class. So I went to the second day, and the second day there was a young man sitting there with reel-to-reel tapes that the provost had asked the class be taped. And with all the dignity of an ass, he proceeded to tell my daughter's story, and it was taped at the same time. And of course, I proceeded to file a retaliation complaint. He was found guilty of this retaliation because on the tape, he says to us, we're the same as Osama bin Laden, and he has no problem with taking an AK-47 to us. In class and on tape, he says this. I then proceeded to file a complaint. Of course, once again, he was found guilty. But the final report says he compared the fictionalized Dow case with Al-Qaeda in an attempt to dramatize the case with association of violence to further intimidate Mrs. Dow. I believe this tactic was again employed for the same reason when he compared the fictionalized Dow case with the resolution stating that anarchy and chaos was the result with this one. Utterly brutal, but yet efficiently totalitarian group that was funded by and controlled by Osama bin Laden, comparing into power. And although we're not, again, talking about states that are far more physically violent and militaristic than the case we are talking about today, the fictionalized Dow case, the process is very, very similar. The report goes on and on. The reason I'm telling you all this is because, again, he threatened us with an AK-47 on tape. He talked with several journalists and with the press, and he shares that story. So it ended up in the newspaper. The path continued. He was found guilty of retaliation, abuse, vulgar behavior, misusing student files, intimidation, harassment, and threatening us with murder. He appealed to UVM, and the president upheld the decision of the Affirmative Action Office. Over 2 years, we contacted many state agencies for help. The university found him guilty, but their hands were tied to do anything to help us. Quote, because it wasn't their fault. They told him not to do it. End of quote. We were unable to find a lawyer, as I said. We went to Alana, we went to Vermont Attorney General's office, we went to Human Rights Office, and finally the ACLU put up on a blog that we were trying to find a lawyer, and someone from Rutland stepped forward. During the process, a box of indigenous bones were being held hostage by UVM. They asked us to drop the case or they would not allow the remains to be repatriated. In discovery, we have found out that this had happened to 10 other women. He was given an early retirement. His status of professor emeritus was taken away from him, and he moved to Ann Arbor, Michigan to teach there. During the case investigation, we got a call from another woman in Michigan in which he was doing the same thing to her, and she had read about our case and wanted to know more. That woman was Amy Goodman from Democracy Now! So as you can see, severe harassment and pervasive behaviors lasted for years. My daughter was so traumatized. She now has 2 children, and she will not let them in a public school. She homeschools them. Harassment in this bill must include severe and pervasive. Severe and pervasive. We won the case. My daughter used the money to buy a new house, and we are thankful for that. But the pain was just too traumatic to go through. And like the other women, I would not say we were privileged, but I would say that we were gifted with the knowledge of how to move forward. And there are many BIPOC people that have this similar problem, and they don't have the knowledge on how to move forward. You have to help them with that. You have to give them, and you can't rely on an agency of education to do that. They can't create a good policy. Thank you.
Judy, and again, appreciate you sharing the story, as painful as it is here for to tell. Representative Belder.
Thanks for your testimony. Would you be willing to tell me kind of approximately when this transpired?
Yeah, it started in 2001. I enrolled in 2002, and it took us 6 years to go through the process of going to court. Yeah. And the case, I don't have the number now, but in the boxes of paperwork, there's a case number that was assigned. And when we gave it to Amy Goodman, she was able to get the whole case record. So I know it's there. I just don't know where. But there is a case for you to look at.
I also wanted to say I'm sorry if you did feel slighted that your case wasn't referenced when, folks have said that it's hard to pursue this because obviously you put a ton of effort into that. I want to honor that and also hope that I think it's also true that in the public schools, it's incredibly challenging, just as it was incredibly challenging to you. So I would try to uplift you as an example of well, in some ways what you shouldn't have to do, but an example of what you did do. And so I'm sorry if you felt unseen by some of those other conversations. But thank you for bringing your story, and it's really important in this conversation. And I don't see the fact that your story wasn't, I see these things as not at odds, and I don't know if you feel the same way, but I just wanted to acknowledge that you said that.
It just feels like it's on a record. I don't know, and it keeps going round and round and round and round because it's story after story after story. Because I've been teaching for 38 years, I've seen it over and over and over. Sit on the SEC committee, and I hear it over and over and over. And for some reason, I think you know those stories exist, but these people have to have help. They have to know the process. Me and I have tried to follow the policy, and they admitted to us, yeah, it's not good, it's not working. Like, no kidding, Shakespeare, and that's what happens with a lot of their policies. They're not good.
Thank you for your perspective on that.
Thank you.
I appreciate it.
Senator Burrow.
Thank you. I do think it's important to point or to have an example of a racially based, very very severe case where your life and your daughter's life were both threatened on more than one occasion with guns. And it was because of the severity, the pervasiveness that you won. I mean, it had to be, this was racially based. Let's not forget, this wasn't just a class.
No, his first words
Yeah.
were about the event, he was drunks and alcoholics.
That's right. So you won, but you won in part because it had to go to those, like, this was a very, very severe and very, very pervasive case. And a lot of families, as you know, in Vermont, don't have the opportunity to take this up to the court level. We hear over and over again that there aren't enough court cases, and that's partly because the bar is so high. We hear over and over again that local districts should be taking this upon themselves, but we don't have we have a rule from model policy from the Agency of Education, which is not required. It is optional, and clearly a district where this kind of behavior is taking place, if they're not doing anything about it, it is in part possibly because the administrators and board don't have people in place who have received adequate training or know what is harassment for protected classes in particular.
Well, that's exactly right. I worked at the Essex Elementary School at the time of the shooting, which was also at the time this was all unfolded. And so in my mind, I'm dealing with the school I work in was just shot up. And he's threatening us in this class with an AK-47. And with 26 law firms at their disposal, they knew exactly what was going on. But that confidentiality between them, that camaraderie between them, stopped them from supporting us and helping us. And I've taught in 205 schools in this state. And it's everywhere. What those women, the stories those women were telling is everywhere. And I gulp every time I hear the story again, because I know it could get to the point of gun shooting. And we have to help these people. This is insane. It's insane. It's everywhere.
Thank you for being here today, Judy.
Thank you for having me.
Representative Lamont.
Thank you. Thank you, Judy. Good to see you outside of our little Zoom boxes.
I know. I don't recognize people sometimes because they're bigger than the inch.
Right. Thank you all. I just want to just name a couple of things to all the folks who testified on this. Thank you all for sharing your stories and bringing light to these situations. I wanted to make just a couple of points to tie it together, if that's okay. One, being leadership does not eliminate you if you are a person of color from experiencing these things. And also, in regards to S-103 and this amendment, I was just going through it again just to see what how this could possibly even really make change, because I'm listening to the stories, I'm listening to the things and the policies that are already in place that are not being enforced and that are not being followed through, and the pervasive harm that is occurring. And so I'm really curious as to the pushback to incorporating and adding students to this protected class, because this really doesn't do anything other than make a statement on what we stand for. And that we want to protect children. Also, it's really our system, our school system, the agency of education in the state of Vermont is failing students of color. And I will say that as a mother in this representative seat whose children are not protected by this seat because they are in fact students of color. We have talked about the methodologies that we take when students experience these things, and it is often isolation and segregation as a means and methodology to protect said students. I just want to add, because I'm not privileged and I don't have the fortune to move or buy a new house or any of those things.
We took a second mortgage out to pay for the class.
Right.
So I could sign up for the class.
Right. And so in my instance, this is why I'm just going to explain why it's important that we include students. Because the harm that they experience and the severance and pervasive that you experienced, Judy, that was extreme. However, students in our current present schools that are experiencing these things by multiple students on a daily basis, that is severe and that is pervasive. However, when the schools are not making incident reports or reporting each and every student, and I can tell you for a fact in my district, there are over 15 cases that are currently being going right now. And from many years ago, there was an incident where a student was beaten by other students and kicked, physically assaulted on camera. And this teacher said, because they used racial epithets. And so then the teacher said, next time, just don't say that. Not don't fight the students. Don't say that next time because it won't be a hate crime.
They don't have the training.
Right.
And neither does the school board.
Right.
So what we're experiencing with the mascot bill is school boards want us to come to talk, but they tell us we can't protect you, we can't make you safe. This is a hot topic in our community. And so last night I listened to what's going on in Brattleboro, and they were included in our list because they're the colonels, and they have groups of kids called the Nels. Colonel, okay? And they actually go after kids and say, the Nels are gonna get you. It happens all the time. And last night on the meeting, they're like, yeah, he didn't own slaves. The guy that was named after. And of course, there's so much history that shows he did own slaves.
Yeah, and so and this ties into the other, thank you for that. And this ties into all of the things that are happening within our school system. It's all connected in the culture that we pass down. And now my son, who's probably not gonna be happy that I'm saying this, but it's okay because it needs to be known that I have a son who the only place that I feel safe, that he is safe, is in my home.
That's common.
And so that isolation that we put to keep people safe, I have been conditioned to use that same tool to keep my own children safe and deny them their quality of life. And so my point is, by us incorporating this, it is a statement on what we stand for in including our children in this to be addressed as a protected class. To shift the culture in which the Agency of Education is going to do whatever they want to do with their policies, so to speak, and however they continue to hold them. However, this is a statement for Vermont, is what is my only. That's my point, because, and which means nothing. It's not going to keep my children safe. It's not going to give my son the confidence to go out and leave the house and go get a job. He's 18. So he's been through the system, right? And now what? Because we don't have When I say we, don't have the social skills to go out and engage because he's not safe in society, in our society.
Which is what I was saying for my daughter. She won't even step foot in a public school now. And even though she lives next door to me, and even though I love having my grandchildren next door to them, I also know, as someone who was taught in schools for 38 years, how much they're missing. And my heart breaks all the time for that.
Thank you. I just want to tie that together and say it affects our children. When our children grow up to become adults, where does that lead them? It's not so different after all.
Said on our shows as well. Same thing.
Thank you. Thank you, Judy. Thank you for the witnesses who were in today. We will be back here after the floor.